I want you to start thinking about the rules of evidence in terms of other courses. The way we think of criminal law with the elements of the crime, the way we think of torts with the elements of the claim or cause of action. We start to embrace that our broad headings of robbery, larceny, or in torts for a negligence claim or maybe an intentional tort, they have these foundational requirements. They have these elements that we want to embrace and that we want to argue either side of. You're either going to argue that all the elements are met, or you're going to argue that the elements are not met because there's something missing from one side to the other. So think of it in terms of evidence. We have the elements of an objection, or sometimes, as we'll get to later on in the course, exceptions to the objection. We got to think about these things. We call them foundational requirements, and you hear this word thrown around a lot in court. Laying foundation, establishing foundation, this lacks foundation. It's really all we're talking about is that all objections have elements. They have these foundational requirements. And for me, there's no better place to sort of understand this and start to piece this together at the front end of an evidence course than the policy rules, rules 407 to 411. After you're through with relevance, after you start to get the understanding of what it means for everything to have to be relevant, maybe even understand sort of the back-end objection, the fail-safe of Federal Rule 403 for unfair prejudice and the other dangers in that rule, the policy rules really start to establish the elements, the foundational requirements. And just leave a footnote right here if you can that we're going to soon get to other rules like hearsay, most famous among them, but also character evidence and other rules that will also have exceptions to them. So at some point, the foundational requirements will not only belong to the opponent, the one objecting, who's going to say, I have this objection, and then meet all the foundational requirements, but there'll come a time when the proponent will say, I have an exception to the objection. In response to your objection, I have an exception, and it too has elements, and I have met them. So let's look at some of these policy rules, and there they are, 407, 408, 409, 410, and 411, offering different places where this evidence, the evidence that's called for in these very specific rules, is absolutely relevant. It does have some tendency to make a fact of consequence more or less probable than it does a trial. And usually that fact makes it more likely that the person is liable, makes it more likely that they'll be found for liability. But you'll see that we have specific policy reasons for not allowing this evidence, especially if you meet out the foundational requirements. If the opponent, the one objecting under these rules, actually meets the elements under the. So there's specific policy rules. These are rules of exclusion. Every time I say objection, subsequent remedial measures under 407, objection, offers to compromise under Rule 8, objection. This calls for liability insurance payments under 411. I am the opponent, I'm the one objecting, and I'm trying to exclude by invoking this rule. So therefore, the foundational requirements of the objection are mine as the opponent, the one sitting down in court while the other side is presenting, putting on evidence, me as the proponent. If they violate these very specific rules of exclusion, these very specific policy rules, I stand up and I object, and I invoke them. Objection, subsequent remedial measures under 407. And you'll begin to see a trend that starts here with these policy rules, and that trend is simple. Among those elements, among those foundational requirements for the objection, includes some improper purpose by the one presenting, some improper purpose by the person putting on the evidence. That is, I am going to meet my objection, 1, 2, 3 foundational requirements. One of those elements, one of those foundational requirements actually includes the proponent. They're trying to do something bad. They have a bad purpose in how they act. And you'll see that that bad purpose will come up and actually be most often where the fight is on the objection between the opponent, the one objecting, and the proponent who is going about their business putting on the work. Don't lose sight of the fact that relevance is still an objection at the front end. Of course, all evidence has to be relevant. So relevance, then maybe a policy rule, and 403 is always that backstop. Even something that doesn't fit, even if you lose as the opponent a subsequent remedial measures objection under 407, 403 is still a backstop because you can still argue how this evidence, should it come in, should it clear all the evidentiary hurdles that you've put in the way by way of these objections, should it clear those objections, 403 is still a backstop because it provides for unfair prejudice and the other dangers in that rule when they, and only when they, substantially outweigh the probative value of that evidence. So let's look at offers to pay medical expenses. This is the easiest of the policy rules. Apparently there was a day when people used to leap out of their cars after an accident and offer to pay the other side's medical expenses. A dated rule, to be sure, because I don't think this is happening all that much in our society, but nonetheless, we want to encourage this behavior. We have a policy reason for encouraging people to furnish and promise to pay medical expenses and hospital expenses. So we have a rule. Even though it's relevant, even though it may lend for liability, we have foundational requirements. And notice, right, is not admissible to prove liability. In this rule, a very simple rule, someone offering to pay medical expenses cannot be used against them at trial to prove that they were liable for the person that they're offering to pay the medical expenses for. And if you look at it, these from the rule constitute the foundational requirements. These are the elements of this objection. If I, as a proponent, wish to object, here are the foundational requirements. It's an evidence to furnish or promise to pay or offer medical expenses in some way to prove liability. And notice what it includes. Some bad purpose on behalf of the proponent. If they're introducing the promise to pay medical expenses for some other reason that does not to prove liability, it doesn't meet these. But notice, as the opponent, I'm going to step forward and say the foundational requirements are met. We have all the elements of this objection under 409, including the proponent's bad purpose. The response, as it goes back to the proponent, turns to the court and says, Your Honor, the foundational requirements of this Rule 409 are not met. Specifically, I'm not offering it for this bad purpose to prove liability. Instead, I'm offering it for some other purpose. Look at it. Here's someone sitting in their hospital bed. The boss walks in and says, Don't worry, looks like it was our fault. Don't worry, the medical bills, we'll pay them, blah, 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 all the way through. Well, at trial, you can imagine if this goes south, we might be worried about this statement from the company to the plaintiff. Well, there's a part of this, not the entire statement, but there's a part of this that is susceptible to Rule 409. And if you're looking at this, you probably start to see it. That's excludable under 409. I would, knowing that that statement's coming, either get out my laptop and file a motion to eliminate, or not knowing it's coming, or sleeping at the wheel, I object at trial. Objection. Offer to pay medical expenses, Rule 409. The foundational requirements are met. This is an offer to pay medical expenses, and they are trying to admit it. They, the proponent, are trying to admit it to prove liability in this case. They're trying to show that they did something wrong. That's why they're offering to pay.